Hi, I'm Kelly from Goins Law, and I'm here to talk to you about the title process.
So, what are some of the big things that you see as an issue that you come across?
In the title process, yes. Some of the major problems that we come across are estates that have not been started. If someone has died who owned the property and they've died in the last 2 years, they will have to have an estate filed in the county where the property is being sold.
What happens if the person died in a different city, state? Does that matter to you guys?
What matters to us is that the estate file is filed in the county where the property is being sold. So perhaps they already have an estate file in another county in North Carolina. We will need certified copies from that estate filed in the county where you're selling the property. So it's a pretty easy process that you can get certified copies and make an ancillary estate in the county where the property is being sold.
If they haven't already started the estate files, everything else, how long would that actually take?
To start an estate file, one of the major things that title insurance is looking for is the notice to creditors being run in the newspaper. And that does have to run for 120 days. But the notice to creditors only has to run one time before title insurance will let you sell the property. So if you start an estate and quickly run the notice to creditors, that issue could be cleared up in a couple of weeks. As a realtor, you're constantly making decisions throughout the transaction and making judgment calls. And when to start title is a judgment call. The reason we always ask, do you want us to start title now, is sometimes you have a feeling this transaction's gonna fall through. Either the appraisal is not gonna come back right, or the inspection comes back with major problems that you're not gonna be able to negotiate. So you wanna kind of wait and see those results before you start title. Once we start doing title work, if the transaction does terminate, we will charge the buyer for the work that we've done. So that's why we always wanna ask before we start, just to make sure that you're okay to incur this cost on behalf of your buyer as part of the process. You don't want to start too early if you think the transaction may fall through, but you also don't want to wait too late. If you hold us off on starting title work until 5 days before closing, we're probably not going to close on time. Title may be clear, but the lender needs time to process all of our title work before they get their loan documents to us.
What are some other things that we should be aware of that might delay the title process, that we want to start that early, or some things that we might need to look at as the list agent to make sure that the closing is going to be on time?
If you are selling a mobile home or your buyer is buying a mobile home, we have to have the VIN number for the mobile home. So that's something that you need to immediately find the VIN number so that we can start our process of checking to make sure that the title has been canceled to the mobile home, canceled to real estate. We check with the DMV to see if there are any liens or if the title is still active. And that's a process, so that can definitely hold up closing if it's not done quickly or properly.
Another thing that we see sometimes that different attorneys in different areas are sometimes lax on or whatnot is estates. In North Carolina, what is the law of who has to sign the deed, CD, everything else?
When somebody owns a property in North Carolina and they pass away, the property is immediately owned by their heirs or their beneficiaries. So that depends on if they have a will or if they don't have a will. If they have a will, the will directs exactly who has the property. So it could be all their children, it could be a nonprofit organization, it could be that they give it to their executor to sell and distribute the proceeds. If they do not have a will, then the state of North Carolina has certain rules about who owns the property. So we need to know if they had parents that are still living, children, a spouse, and North Carolina law determines who owns what percentage.
If there's nobody that gets the property from the will, do all the heirs have to sign?
Yes. All of the heirs of the property would need to sign, and their spouses if they are married. So if dad dies and has 3 kids and 2 of them are married, we have 5 people signing if he wasn't married when he died.
Let's go ahead and go best case scenario. We've got a client who's got a somewhat new construction property. They're married. Everything's good to go. They're just buying another house and selling this one. What would be the best case scenario for you guys to start title work? How long would you actually want before closing?
We like to be able to deliver title work to the lender 2 weeks before closing. So we schedule out our title work and our attorneys do the title work. So we would like to know about 2.5 weeks before closing, maybe 3 weeks, that we can start title work. That way we can get it scheduled within the next few days and get it to the lender to keep everything on track. That also gives us enough time to clear any title problems that we come across.
Do you charge extra for rush title work?
We don't. We used to charge extra, but we don't charge extra anymore. But we just let you know that if you hold us off on our title work until it's almost closing time, it could delay the closing.
So really, you can't push it any faster because there's a lot of hands that are going on. Even if it's a perfectly clean and clear title, it might sit on the underwriter's desk for a little bit.
And it depends on the lender. Different lenders are easier to work with when it comes to crunch time. They have a team that can receive our title work and then turn around and issue their loan documents very quickly. And then some of them, they're
terrible.
They're less flexible. We'll say that, less flexible.
What are some other issues that you see on title work that might come across the table in the transaction?
Let's talk about separation and divorce. So if you are representing a buyer who is separated and wants to purchase a property in their own name without their spouse that they're separated from, that's fine. They can be on the deed by themselves and the loan by themselves. Their spouse doesn't have to come to closing to sign anything. However, if they do not have a free trader agreement in place, if their divorce is not finalized and they want to sell or refinance the property, they're going to have their spouse sign with them on any deeds, any mortgages in the future if there's a delay in their divorce decree. So we recommend that if you are separated and you're buying a home, you need to have a free trader agreement in place saying that the marital rights are severed and you own this property free and clear by yourself.
What about if you're selling?
If you are selling a property and you're married, in North Carolina, your spouse has to sign on the deed to sell the property, unless you already had a free trader agreement in place that severed the marital interest.
So even if I bought the property before I was married?
Yes, if you bought property in your own name before you're married, but then you get married, then when you sell the property or you refinance the property, your spouse is going to have to sign. So even if you refinance the property, it's in your own name, they're not on the loan, they still have to sign the deed of trust.
On title work, another issue that I've seen come across the board is whenever a company is selling a property. What are some situations that when an LLC or an S Corp is trying to sell a property that they might incur to delay closing or not be able to close at all?
When a business is selling a property, the first thing we do is go to the North Carolina Secretary of State website and pull their business registration. We have to make sure that they're in good standing with the Secretary of State. If they're not in good standing, then they cannot sign to sell property. We also look to see who are the member managers of the LLC or the president of the corporation, and we generally require a resolution. If someone other than the people that are on the Secretary of State registration are signing, then we need a resolution from the company saying who can sign to sell the property. If they're registered in other states, we can also pull their information from Secretary of States of other states, but they don't always have all the information that we need, so we will definitely require a resolution.
If you have a power of attorney for a parent or something of that nature that you're taking care of them, can you use that in a real estate closing?
So we would want to review the power of attorney to make sure that it says you can use that power of attorney to sell real estate, because it can be specific about what powers it's giving away. We would just want to review it. We also have to record that power of attorney in the county where we're recording the deed. So In order to record the power of attorney, we have to have the original. So if you only have a copy, we're going to have problems.
And you have to go to where to go get the original power of attorney?
Probably grandma's box or something in the attic. Hopefully you kept that as a very important piece of paper.